Good morning. So nice to see you all. I share Laura's enthusiasm for speaking to you today. And I wanted to tell you that since the last time we saw each other, I turned 50 and 51 and 52. So I'm going to keep it short and sweet on the topic of estate and gift tax law update. And then we'll turn it over to the millennials to tell you about the rest of it. We're going to start the presentation discussing the federal estate, gift, and GST tax. The two things that you should be taking away from what's going on right now with the federal estate, gift, and GST tax is that we've had a dramatic increase in the federal estate tax going from 2021 to 2022. The increase is $860,000, which is the largest increase we've ever had, and that is due to inflation. So as a result of the high inflation, we have a 9.3% increase in the exemption. We also have a $1,000 increase in the annual exclusion. So what does that mean for us? Well, first of all, it means that our clients can do more tax-free gifting, and we should be encouraging them to do so. They can fund things like certs and slats, and other just general gifts to their children and more remote descendants. Moreover, married couples can give $1,720,000 in 2023. So that is also a very dramatic increase. Another portion of what's going on right now with the interest rates is that we also are in a bear market. So when interest rates increase and you're in a bear market, it changes our opportunities with regard to gifting. Over the past few years, we've been doing a lot of grats and loan transactions and sales to grantor trusts because those are favorable interest rate transactions. So if you have a low interest rate, you can do a grat, and when you do a grat, by way of background, if you put money in a grat, you take back an annuity interest in what you gave away. And that annuity is based on the value of what you put in, as well as the interest rate at the time you make the gift. And in order for a grat to be successful, what happens is you take back an annuity, and if the performance of the asset in the grat exceeds the value of the annuity, which I just said was the value of what you put in and the value of the interest rate on that money, then the balance goes tax-free to the beneficiaries of the grat. So what is favorable for that kind of transaction is a low interest rate and a low value. So those types of transactions have been very, very successful over the past because the interest rate has been very low. So our hurdle rate is very low. Now we have a high interest rate, which kind of flips that whole idea on its head, making grats less attractive, loan transactions where we make gifts and loans to our family less effective, and has increased the effectiveness of other types of gifting transactions, such as CUPERTs and charitable remainder trusts, which actually rely, depending on what your mindset is with them, on having higher interest rates. Because in a CUPERT, you are giving away a property, qualified personal residence trust, you're giving away a property to a trust, and you are retaining the right to live there. And the gift is the value of what goes to your kids after a certain period of time. And what you retain is the value of the property, and which is dependent on the interest rate that applies at the time. As a result, if we want to make the gift to the CUPERT smaller for the next generation, the amount of exemption we can use, then we would like higher interest rates. So we're flipping this thing on its head, and it's different than it's been in the past few years. The other thing that you should note, apart from the high inflation that took place and increased our exemptions and the higher interest rates and bear market that are affecting our gifting strategies, is that in 2026, the federal estate tax is sunsetting, which means that it's going to be split in half. Look at this slide again, you'll see that in 2026, the federal estate tax exemption is going down to $5,490,000. A lot of people don't know why that happens, and it's because of something called the Byrd Rule. And it's based on a gentleman named Senator Robert C. Byrd. And he was a very interesting character. He was the senator from West Virginia. He served the longest term in Congress of any senator. And he was served in both the branches of the state legislature in West Virginia and in Congress. He was in the House of Representatives and the Senate. And he began his political career by organizing and leading a local chapter of the Ku Klux Klan, which he said later was the greatest mistake he had ever made. But perhaps most interesting to me was that his given name was Cornelius Calvin Sale Jr. Nothing says trust me and make me a senator than having a name of a carnival barker. Mr. Byrd proposed a rule in 1985 in which he said that he wanted to prohibit the inclusion of extraneous provisions in the budget proposals. This included provisions that increased the deficit beyond the budget window of 10 years, which means that when this law was passed in 2017 and the Congress looked at this, what effect this was going to have on the budget, it was going to cause a deficit spending situation over a 10-year period. So in order to get around this Byrd rule and be able to pass this law, they had to have it sunset in 2026. So that's what we're facing in the future as to what's going to happen with this tax. And that's what we are telling our clients they have to hedge against when they're doing their gifting now to get ahead of this tax. The Connecticut estate tax has had a very interesting year as well. In 2023, Connecticut exemptions are going to be tied to the federal exemption. So currently, Connecticut has a $9.1 million exemption in 2022, but that number is going up dramatically by $3,820,000 in January 2023, which is very good for Connecticut residents because we've always had sort of trouble planning for Connecticut residents because they couldn't maximize the use of their federal estate tax exemption in their gifting because they'd have to pay a Connecticut tax. And that Connecticut tax is around 10 to 12%. So it was prohibitive to make those types of gifts. But now we don't really have that same type of issue with our Connecticut residents. But the downside of that is that they also have the same sunset, because now that it's tied to the federal rules, the sunset in 2012 is going to apply to the state of Connecticut. So we have to, again, get ahead of that if we want to make sure that our clients are doing their gifting and utilizing their full exemptions by making those gifts now before the sunset comes about, if the sunset comes about. For Connecticut residents, it should be noted that it is always better to give property that's in a state that is not Connecticut, because Connecticut is the only state with a gift tax. And that gift tax, like the federal gift tax, is tied to the Connecticut exemption for estate tax purposes as well. So if you use Connecticut gift tax, you're actually reducing your Connecticut estate tax at the time of your death. So the best way to preserve as much Connecticut estate tax as you can, and gift tax, is to give property that is in another location. And by property, I mean something literally sitting in that location, like real estate or something that has a physical locus in a different jurisdiction. And as a result, there's lots of states around here where our clients have houses that have an estate tax, but not a gift tax. Maine, Vermont, Massachusetts, Rhode Island, New Jersey, Delaware, Maryland, all of them have an estate tax, but not a gift tax. And their estate tax is across the board, has a lower exemption than Connecticut. I'm giving Connecticut a push here. And a higher tax rate, top tax rate of 16%, generally speaking. So Connecticut actually is not the worst state to die in. It's the worst state to gift in, or it was. So one of the states that also has an estate tax but no gift tax is New York. The New York gift tax is very punitive, but I'm not going to talk about the real punitive nature. I know that Dan Fitzgerald's going to talk about that later, but I did want to point out that the New York tax exemption is much lower than the Connecticut. It's $6,110,000. There's a 16% tax rate. So while that did go up by $180,000 from last year, from this year to next year, I should say, it is not a very generous state when it comes to dying. So it is a very good idea to get New York property out of your clients' estates if you can during their lifetime. So that's pretty much all I had to say on this topic. And just to summarize, I just wanted to say now's the time to make large gifts, and it's best to gift property in states that have an estate tax but no gift tax, I should say. And Senator Byrd was a very complicated person. So thank you very much.